Hello, I'm Constitutional Attorney Catherine Henry, and welcome to the Constitution segment recap for Season 2, Episode 23 of Restore Freedom Weekly. We had a lot of technical difficulties, and so we ended up with three different portions of live stream and a fourth video that was uploaded, all important, and that's why we stuck with it, to make sure you had all the information on these five new important Supreme Court of the United States court opinions. So with that being said, we're going to roll right on into it. Like I said, this is just a simple recap. So to hear that full discussion, although it is a bit bumpy, go ahead and check out the link that's on page 2 for the slideshow, and you'll be able to watch the video in full with all the parts. All right, so there are five new important Supreme Court of the United States decisions. Now, these are 5 out of the 10 most recent decisions. These are the ones that when I looked at the top 10 or the most recent 10 most recent decisions from the United States Supreme Court, I saw these 5 and they stuck out to me as something that you would want to know about. Why? Because they cover topics like free speech, religious accommodations, limits on the powers of administrative agencies, duties and limits of state legislatures, the protection of private property rights, racial justice, and more. Now, courts don't make laws, but their opinions can't simply be ignored, so that's why we've undertaken the task of informing you about these important cases. Also, make sure to check out our true or false questions, which we still do. We just do them on YouTube now. We weren't getting enough responses on other platforms to continue doing them there. But every Tuesday between 10 a.m. and 10 p.m., you can answer the true or false question of the week. And just make sure to check back at 10 p.m. for the answer when it'll be posted there. So, another reminder before we get into the substance of these 5 cases is check out Article 3 of our U.S. Constitution, because that is where you'll see the judicial power of the United States. Now, the judicial power is necessarily separate and distinct from legislative power. Legislative power is the power to make laws. So there is no power to make laws in the hands of the judiciary or the court system. So there's no case law. There's case precedent, and we've had a lot of videos discussing that very topic. Now, the separation of powers topic is something that it's not word for word written into the Constitution, although common sense would indicate you look at Article 1, it's separate. Article 2, those powers are separate, and Article 3, and those powers are separate, and they're delineated that way for a reason. Now, you look at some state constitutions, like the Michigan State Constitution, Article 3, Section 2, and you'll see the words separation of powers of government written right on in to the text of the Constitution. So, despite what any court says, keep in mind that the U.S. Constitution always remains the supreme law of the land, and oftentimes courts get it wrong. In fact, you'll see in the decisions we'll talk about today, the 2 that we'll go into the most detail about, they admit that they have gotten it wrong many times and for far too long. Now, these 5 important decisions are Biden v. Nebraska, Groff v. DeJoy, 303 Creative LLC, Moore v. Harper, and Students for Fair Admissions versus Harvard. And if you look at this slide, you'll be able to see the list of the 10 most recent decisions right on the U.S. Supreme Court's website. If you click the purple link right through the actual slideshow today, you'll be able to see this portion of their website pull directly up, and you can click all around and see all the decisions that they've made recently. You'll also see on the first slide where we're talking about each of these 5 cases an orange link, and that is for the decision itself for that exact case. So that's the slip opinion, as it's called, before it makes it into the book of published decisions from the U.S. Supreme Court. So make sure to check out all of those as well. Now, the United States Supreme Court itself has said that the Biden v. Nebraska case stands for, well, the Secretary of Education does not have the authority under the HEROES Act to establish a student loan forgiveness program that will cancel $430 billion in debt principal and affect nearly all borrowers. So there's two things to take away here. One is a practical matter. If you're a student loan borrower and you were thinking, oh my gosh, a portion or all of my student loan debt might be erased, that's no longer a thing. That's not going to happen. But the more important thing to consider is what the Supreme Court is recognizing about administrative agencies. Now, they're not going far enough in recognizing the full unconstitutional nature of administrative agencies, but what they are doing is recognizing that administrative agencies have no powers beyond what Congress gives them specifically by statute. If there's no law that says an administrative agency can do XYZ, they simply can't do it, period. All right, Gruff v. DeJoy, that's one that you need to check out. It's about religious accommodations. And basically, it's putting the burden onto the employer if the employer wants to deny a religious accommodation. Now, there can be some bad consequences out of this, and we talked about that more in depth in the full episode. But there are some good consequences about this. In fact, think about all of the religious accommodations that people have tried to seek in the last few years, just with the mandates that have been happening one after the other by federal government agencies and state government agencies and local government agencies. Well, this is something that is paving the way to recognize that if a government agency wants to stop you from having a religious accommodation, then they are bearing the burden of proof to essentially show that it's not something that they can abide by. Okay, so moving on, 303 Creative LLC, the United States Supreme Court says that the First Amendment prohibits Colorado from forcing a website designer to create expressive designs. Specifically here, she was talking about expanding her website design business to doing wedding, maybe photography, videography, but website design specifically for weddings, and did not want to be forced to do websites for gay or lesbian weddings, although she would do other kinds of websites for them. Just didn't want to put her creative touches and put her passion and drive and talents behind something that her religious beliefs do not allow her to support. So that is what is at issue here. And of course, Colorado thinks that they can tell you to do whatever you want to do, although they think everybody should be able to be high. So apparently the people who made these laws are high, I guess. I don't know. But some good things that came out of this decision, a simple one to share with you first. If liberty means anything at all, it means the right to tell people what they do not want to hear. And secondly, in this case, these are the exact words of the United States Supreme Court. In this case, Colorado seeks to force an individual to speak in ways that align with its views, but defy her conscience about a matter of major significance. In the past, other states in Barnett, Hurley, and Dale, those are other cases, have similarly tested the First Amendment's boundaries by seeking to compel speech they thought vital at the time. But as this court has long held, the opportunity to think for ourselves and to express those thoughts freely is among our most cherished liberties and a part of what keeps our republic going. Of course, abiding by the Constitution's commitment to the freedom of speech means all of us will encounter ideas we consider unattractive, misguided, or even hurtful. But tolerance, not coercion, is our nation's answer. The First Amendment envisions the United States as a rich and complex place where all persons are free to think and speak as they wish, not as the government demands. Because Colorado seeks to deny that promise, the judgment is reversed. So just poetic words to support our First Amendment liberties. And that moves us right into Moore v. Harper, which we're only going to start on briefly here before we'll have to pick it up in part 2 of a Constitution segment recap video. But part 1 here, I'll tell you that the court says, even though this case is about gerrymandering, it's about an equal protection argument. This is people who sued the state legislature essentially for redrawing their congressional districts after the census came out. And they're saying that the redistricting is gerrymandering and it violates their rights to equal protection under the law and to be able to have proper voting representation, etc. And what's interesting is that the court says, no, the question here that we're concerned with is whether the Elections Clause of the U.S. Constitution insulates state legislatures from review by state courts for compliance with state law. So essentially, what they're saying here is that the issue is not what we believe it to be. So we'll pick that up in part 2 of our Constitution segment recap. So make sure to click on that in just a moment. Hello.
Make sure to like, follow, subscribe, and share. Restore freedom.